Thank you, Lashkan Corla. Minister, this question just relates to the reorganisation of the workplace relations architecture within the state, and just how that reorganisation is progressing and the impact it's having on the current caseload of the
Minister.
The Deputy will be aware that as part of the current reform of workplace relations services, the functions of the Employment Appeals Tribunal will be transferred to the Workplace Relations Commission and the Labour Court insofar as to the Labour Court insofar as first instance complaints and appeals respectively are concerned. So that's first instance to the WRC, appeals to the Labour Court. The Employment Appeals Tribunal will continue to function for a limited period after the establishment of the WRC to finalise complaints and appeals which were lodged before commencement of the enabling legislation, and will be dissolved on finalisation of those legacy cases. The objects of the reform programme are to deliver a world-class workplace relations service which is simple to use, independent, effective, impartial and cost-effective, provide for workable means of redress and enforcement within a reasonable period, and reduce costs. The Workplace Relations Bill, which returned to the Dáil this week, will make statutory provision for the new structures, while also providing for a number of innovative measures, including the use of compliance notices and fixed charge, the sharing of employment information between the WRC, the Labour Court and other official agencies, and so on. You know those. Significant progress has been achieved to date in advance of the enabling legislation to put in place the technological, structural, administrative and staffing changes required to underpin the workplace relations programme. I am pleased to say that some 19 new adjudication officers selected for appointment following an open competition conducted by the PAS will shortly complete an accredited training programme. These adjudicators, together with the current cohort of equality officers and rights commissioners who will be appointed as WRC adjudicators, will be available for deployment on the establishment of the WRC. The adjudication resources at the disposal of the Commission will therefore comprise a diverse group of experienced industrial relations and HR practitioners, employment lawyers and civil servants with appropriate skills and experience. A key commitment in the workplace relations reform is to place the needs of users and stakeholders at the very core of the service delivery and to reduce the administrative burden involved in customer interaction with the service.
Thank you, Minister. Deputy Thomas Pringle.
Minister, the changes are taking place and the 19 new adjudication officers are being appointed, as you say, but I'm just wondering about how these proposed changes are affecting the current workload of the Employment Appeals Tribunal, because I know of cases that are taking over 2 years to actually come before hearings and try and get a resolution, which is a very difficult situation for former workers who may have been unfairly dismissed and have this continuous wait to try and have their cases heard, so that they can bring some sense of closure regardless of what the outcome is, so that they can move on with their lives. And I'm just wondering, is the proposed changes having an impact on the current workload in terms of developing some sense of inertia or lack of understanding of what's happening and how things will progress, and what efforts are being made that the workload can be cleared in advance of the new structures coming?
Thank you, Minister.
Yeah, absolutely. A huge amount of change has been done, and it is a credit to the people working in this area. We're effectively merging 5 bodies down into 2, and there's been huge support from those involved in simplifying the process, reducing 30 forms down to 1, developing an online procedure where people can apply, making sure that there's a pilot early resolution so that cases that can be resolved without going to hearing can be drawn aside to avoid the long wait for a hearing. The delays in hearing a rights commissioner are being reduced, and they are very quick turnaround now. You're right, there is a legacy on the Employment Appeals Tribunal, but those waiting times are also being reduced. But it is true that after we set up the WRC, there will be a legacy period, and there will be a period to work down those legacy cases, and we are making provision to plan that as effectively as we can to minimise delay. Some of them are highly complex cases. They've had legal referrals to courts and so on. They've had adjournments. This is a difficult process, but we believe that the new process will be much more effective. But we are working through that backlog as effectively as possible.
Deputy Thomas Pringle.
Minister, would it be a case that staff that should be working on current cases that are in the Employment Appeals Tribunal system are actually working on setting up the new systems, and that is leading to the delays in cases being heard and taking place? Because I do believe that 2 years is far too long for anybody to be waiting to have a case heard and to have that closure to that episode within their working life, whatever the outcome of it. So, I mean, are you doing this with the existing staff? doing basically double jobbing while this changes are taking place, and is that having an impact on actually the caseload and how it's been progressed?
Thank you, Minister.
No, we haven't deflected any staff from the hearings or to proceed with cases. What we've done is simplified the whole procedure. There were cases where the same case was being run parallel into two different hearing routes. So you'd have the same substantive case effectively heard in two different arenas. We're streamlining that so that what has been made is, as I say, reducing 30 forms down to one. The whole thing has been about simplification, making it user-friendly, having a quicker interaction, spotting cases that perhaps have been wrongly put together, making sure that they didn't proceed a long period before then they were sent back to the start. So it's been a lot of work just to streamline that process. It had been a very complex process, and that has been the objective, to make it easier. So no resources haven't been moved from hearings into that other administrative improvement. I pay tribute to the staff who have been extraordinarily flexible in managing the change. It has been remarkable in the space of the period.
Thank you. Deputy Attorney